Hey everyone, it's Layla Shaver. We're going to go ahead and get started. So this week we are talking about custody issues and chief compliance officers. So this is the actual custody rule, Rule 2064-2. The custody rule provides that RAs that have custody of client funds and securities must use a qualified custodian, such as a bank or registered broker-dealer. And under the rule, RAs are deemed to have custody of client funds or securities that are held by related parties that are qualified custodians as well. The rule requires RAs to provide written notice to the clients when they open an account, the qualified custodian on the client's behalf, requires annual surprise examinations of RA client accounts by independent auditors, and requires the RAA's independent auditors to file a report of the results of their inspections with the SEC. Now, I'm not going to go through the actual law right here, the actual rule. I'm going to break it down for you in more simpler terms. So when does an RAA have custody? The RAA has custody when an advisor directly or indirectly holds client funds or securities, or when it has the authority to obtain possession of them. And RAA is also deemed to have custody if certain persons who are related to the RAA hold client funds or securities or have authority to obtain possession of them. The custody rule provides 3 examples of situations where an RAA would be deemed to have custody. The first is if the advisor has actual possession of client funds or securities. Now, something to note, there are 2 exceptions, and that's when the advisor holds a check that the client wrote that is payable to a third party, or when the advisor inadvertently receives client funds or securities and then returns them to the sender promptly, meaning within 3 business days of receiving them. Another time that an RA will be deemed to have custody is if there's any arrangement under which the advisor is authorized or permitted to withdraw client funds or securities maintained with the custodian upon the advisor's instruction to the custodian. If the advisor has a capacity under which the advisor or supervised person has legal ownership or access to client funds or securities, that would also be deemed having custody. Now, such a capacity would generally include an investment advisor who manages a pooled investment vehicle, such as a general partner of a limited partnership, or the manager of a limited liability company, or something comparable, or a trustee of a trust. So the custody rule imposes the following requirements on an RAA that has direct custody of client funds or securities through possession or authority to obtain possession of them. So they have to use a qualified custodian. So these client funds and securities have to be either in a separate account under each client's name, or in accounts that contain only client funds and securities under the RA's name as agent or trustee for the clients. The SEC has identified 4 kinds of financial institutions that are qualified custodians for purposes of the rule. And those include banks or savings associations that have deposits insured by the FDIC, registered broker-dealers holding customer assets and customer accounts. Keeping in mind, you can have broker-dealers that are registered that are very limited in scope. So you'd have to make sure the broker-dealer actually holds customer assets and customer accounts. Registered futures commission merchants holding funds, securities futures, or securities incidental to commodity contracts and options. And foreign financial institutions that customarily hold financial assets for their customers, provided that the institution keeps these assets and customer accounts segregated from its own proprietary assets. Now, of course, some advisors are themselves institutions that meet the requirements for being a qualified custodian, and some advisors have custodial relationships with affiliates that are qualified custodians. If the qualified custodian fulfills the obligations for acting as one, then there's no prohibition against those types of relationships. So, for example, a lot of advisors are duly registered. They have their own RAA, and then they're also a registered rep of a broker-dealer through which they that holds their client accounts and assets. So those relationships are fine so long as they meet the obligations and definition of a qualified custodian. Excuse me. So second, when you have direct custody, you have to send notices to clients. So when an RA opens an account with a qualified custodian on the client's behalf, the RA must promptly notify the client in writing concerning the qualified custodian's name, address, and the manner in which the client's funds or securities are maintained. The RA must also provide prompt written notice of any changes in this information. So if the RA sends its own account statements to clients to which it is required to provide notice, it must also include in the notification a statement urging the client to compare the account statements of the custodian with those of the advisor. We're seeing now most advisors aren't really doing that themselves. They'll say, you know, expect statements and confirms and notices to come from your qualified custodian, and then you know, the advisor may be providing additional reports on, say, an annual, semi-annual, or quarterly basis. And in those instances, we'll say, you know, you're still responsible for comparing to the qualified custodian's account statements. The RA must establish that it has a reasonable basis after due inquiry for believing that the qualified custodian delivers account statements at least quarterly to each RA client whose funds or securities that the qualified custodian maintains. The account statements must identify the amount of funds and of each security at the end of the period and set forth all the transactions in the account during the period. The RA can satisfy its obligation to establish a reasonable basis for believing that the qualified custodian is delivering the required account statements by either A, receiving copies of the account statements sent to each client, or B, receiving a written confirmation from the custodian that the account statements were sent to each client. Providing website access to account statements is not sufficient because the rule requires account statements actually be delivered. With respect to the shares of publicly traded mutual funds, the advisor may use the mutual fund itself or the mutual fund's transfer agent to act as qualified custodian and to deliver account statements to clients. Now, an RIA must enter into a written agreement providing for verification of the funds and securities in custody with an accountant that meets the independence requirements of the rule, and that accounting firm must be registered with and subject to the inspection and oversight of the Public Company Accounting Oversight Board, or PCAOB, in accordance with the rule. The agreement of the accountant must provide for the following items. The accountant will provide annual inspections to verify client funds and securities by actual examinations at a time chosen by the accountant without prior notice or announcement to the advisor. And it has to be irregular from year to year. So they can't say, you know, the surprise, you know, we're doing it February every year. No, it has to change from every year. If you are subject to the custody rule, the first examination must occur within 6 months after the RAA becomes subject to the custody rule and not later than 6 months after the RAA obtains an internal control report. The accountant will file to SEC within 120 days after the inspection a certificate on Form ADV-E stating that the accountant has examined the funds and securities and the nature and extent of the examination. If the accountant finds any material discrepancies during the course of the examination, the accountant will notify the SEC within 1 business day by fax or email, followed by first-class mail, directed to the director or the Office of Compliance Inspections and Examinations. Upon resignation, dismissal, or some other form of termination, the accountant will file within 4 business days a Form ADVE that states the date of the termination, the contact information of the accountant, and an explanation of any problems related to the scope or procedure of the examination that may have contributed to the termination. The RIA must also obtain within 6 months of gaining custody, and then no less frequently than once each calendar year thereafter, a written internal control report from the independent accountant. The report must meet the following requirements. The internal control report must include the opinion of the accountant as to whether the controls have been placed in operation as of a specific date and are suitably designed and operating effectively to meet control objectives relating to custodial services, including the safeguarding of funds and securities held on behalf of advisory clients during the year. And the internal control report must also include a verification of client funds and securities and a reconciliation of them to a custodian other than the advisor or related person. So with indirect custody, an RIA can have custody of client fund securities that are indirectly held by a related person. A related person is any person directly or indirectly controlling or controlled by the RIA or any person under common control of the RIA. When an RIA has indirect custody of client assets through a related person, all of the same requirements apply that apply in the context of a direct RIA custodianship, except that the internal control report requirements will apply to the related person rather than to the RIA. If, however, a related person custodian is operationally independent, then there is no requirement for independent verification of client funds and securities. Someone is presumed not to be operationally independent unless these conditions are met, and if no other circumstances can reasonably be expected to compromise their operational independence. So to be operationally independent, the client assets in the custody of the related person must not be subject to the claims of the RIA's creditors. The advisory personnel must not have custody of or possession or direct or indirect access to these assets, or the power to control the disposition of the client assets to third parties for the benefit of the advisor or its related persons, or otherwise have the opportunity to misappropriate those client assets. Advisory personnel and then the personnel of the related person must not be under common supervision. And advisory personnel must not hold any position with the related person or share premises with the related person. And that's key, because a lot of these situations you have employees that are shared between the two entities, or they're sharing premises. If an RA has a related person, qualified custodian, who it treats as operationally independent, the RA must maintain a copy of a memorandum concerning the basis for its determination that the related person is operationally independent, and that has to be kept for a period of 5 years as part of your books and records requirements. Now, most state registered investment advisors will also be deemed to have custody if the investment advisor has the ability to have fees deducted from the client's account and paid directly to the investment advisor by the account custodian. But generally, they will provide for exemptions for having, the report, having an independent accountant, and they may just require a fee notification statement to be sent to their clients or at a time prior to or the same time as when the fee will be deducted to a client, at a minimum showing the total fee and the manner in which the fee was calculated, and then also requiring that you state in Form ADV Part 2 that you intend to put these safeguards in place. So some recent guidance that came out in the last year or so is dealing with standing letters of authorization. So in an effort to provide premium service to clients, it's common for financial advisors to get a standing letter of authorization. And that allows the advisor to enact money movements in and out of the client's account. Now, the use of these flows and other disbursement authorizations allow advisors to act based on a client's verbal request without troubling them for additional paperwork and signatures every time. So for first-party transfers that involve checks, journals, or an ACH, the RA can avoid being deemed to have custody by getting the client's signature each time a transfer is authorized. For a wire transfer, the RA can avoid having custody if prior to each transfer, the RA gets the client's signature as well as the destination account number. Now, when performing a third-party transfer, an RA can avoid being deemed as having custody by following the 7 guidelines below, which actually were provided in the SEC's guidance. And that is the client provides an instruction to the qualified custodian in writing that includes the client's signature, the third party's name, so where we're sending this, who are we sending this money to, and then either the third party's address or the third party's account number at a custodian to which the transfer should be directed. So who are we sending it to, where are we sending it to? The client then authorizes the investment advisor in writing either on the qualified custodian's form or separately to direct transfers to the third party either on a specified schedule or from time to time. The client's qualified custodian performs appropriate verification of the instruction, such as a signature review or other method to verify the client's authorization, and then provides a transfer of funds notice to the client promptly after each transfer. The client has the ability to terminate or change the instruction to the client's qualified custodian. The investment advisor has no authority or ability to designate or change the identity of the third party, the address, or any other information about that third party. The investment advisor has to maintain records showing that the third party is not a related party of the investment advisor or located at the same address as the investment advisor. So there can't be any link between the advisor and the third party the funds are going to. The client's qualified custodian then has to send the client in writing an initial notice confirming the instruction and an annual notice reconfirming the instruction. So then, so long as we're meeting these 7 guidelines, then again an RA can avoid being deemed to have custody. So that really kind of concludes the big kind of hot topic items when it comes to custody. There's obviously a lot of situations where custody can become an issue. Actually, recently, a client or a potential client had a consultation with me. We discussed, his firm wanted to take client passwords and usernames and keep them and be able to access their accounts. Now, again, this is a situation where that firm would be deemed to have custody as a result of maintaining that login information for the clients so they have access to the client's funds and securities. And keeping in mind there are actually some states like Pennsylvania who have taken the position that saving client login information and utilizing that to make trades in their account is actually misleading and fraudulent, and would draw the ire of the regulator and put you, in a position to be disciplined by the state. Some custodians may allow it, others may not. And if you're not letting the custodian know that you have that access, you could actually be violating the terms of the contract the client has with the qualified custodian, and thereby, nullifying certain protections that they would otherwise be given by the qualified custodian in terms of if there was a hack to their account or something like that. There are different instances where custody issues come up, and I thought I'd share that one as it was something that came up recently with a potential client. Now, the other kind of topic we're talking about today are CCOs. Ultimately, your CCO, your Chief Compliance Officer, is responsible for ensuring your firm has a culture of compliance, is maintaining the compliance culture, training employees. They're responsible for ensuring that the compliance responsibilities are met by the firm. So Rule 206.4.7 creates and delineates the role of the CCO. The CCO must administer the investment advisor's policies and procedures, and that involves direct responsibility for the implementation of policies and procedures. And unless the CCO adopts supervisory responsibility for a specific task, the CCO's role is limited to administering the firm's policies and procedures. The rule requires investment advisor firms to appoint a CCO but does not specify the type of experience or education required. In its final rule release for compliance programs, the SEC has stated that a CCO should be competent and knowledgeable regarding the Investment Advisors Act, empowered with full responsibility and authority to develop and enforce appropriate policies and procedures for the firm, and in a position of sufficient seniority and authority within the organization to compel others to adhere to the policies and procedures in place. The SEC requires that the SEC requires, sorry about that. The SEC requires that the CCO be a supervised person of the firm, a requirement interpreted to include outsourced CCOs. And I'm going to talk about outsourced CCOs because we're seeing a growing trend of firms where the CEO no longer has an interest or desire to take on the role of CCO, or has come to the conclusion that they're not competent or simply don't have the time to do it. So we're seeing an upward trend in advisory firms that are outsourcing the CCO role. Now, given the need for expertise and costs associated with carrying out a CCO's responsibilities, we're not surprised to see an increasing number of investment advisor firms using outsourced CCOs. Now, there are, of course, risks associated with that, and you have to weigh the costs and benefits of using an outsourced CCO versus having an internal one. Also keeping in mind that CCO services are convenient and cost-effective, especially when you're considering the cost of hiring and designating a CCO, and training them, and then just dealing with turnover as well, because that'll happen. That cost should be a consideration, but it shouldn't be the only factor that you consider when hiring an outsourced CCO. An internal CCO may lack the time or expertise to do the job properly, whereas outsourced CCOs generally have tons of experience and knowledge, And CCOs and investment advisor firms of all sizes can often benefit from having assistance with both routine tasks and complex regulatory matters. On the other hand, you have to also consider that culture of compliance is something that's built. You can't just purchase that culture. So even if you do have an outsourced CCO, that culture of compliance has to be built from within the firm. So the SEC released a risk alert, examination of advisors and funds that outsource their compliance officers. And they discussed that over the course of 20 examinations, the SEC observed investment advisor firms experiencing varying degrees of success with outsourced CCOs. In cases where the outsourced CCO was generally effective in administering the firm's compliance program, the SEC staff observed the following traits: regular, often in-person visits, communication between the CCOs and firms. There's a strong relationship established between the CCO and the firm, sufficient firm support of the CCO, sufficient CCO access to firm documents and information. CCO is knowledgeable about the regulatory requirements in the firm's business, which if you look at the qualifications of the CCO that we went through before, we talked about competence and knowledge of the Investment Advisors Act, empowerment with full responsibility and authority to develop and enforce the compliance program, and then having a position of sufficient seniority and authority to compel others to adhere to the compliance policies and procedures. And that would include the decision makers, the executive management team, the CEO. So, seeing the flips from the SEC where outsourced CCOs are effective, it's a reflection of the actual qualifications of that position. So that's where we see the issues with outsourced CCOs is when they're not adhering to these qualifications, when they don't have the power to compel others to adhere to the compliance program. They don't have full responsibility and authority, when they're not competent and knowledgeable. A company that just provides you templates, they're not meeting these qualifications. So that's where we see the issues. So where the SEC found that outsourced CCOs failed to have adequate policies and procedures, they failed to compel others to follow the policies and procedures. They may have had them, but no one was following them. And in some instances, the outsourced CCO was named the responsible party for carrying out a compliance task that should have been assigned to someone else, or that was assigned to someone else, and that's just not reflected. One of the major weaknesses of the outsourced CCO that the SEC found was the lack of regular on-site communication with the firm's employees, managers, and directors. Another area is that CCOs have struggled to assert authority to a degree necessary for the CCO to fulfill its compliance duties. And in this risk alert, in at least one recent enforcement action, the SEC held an outsourced CCO personally liable for his own alleged negligence in relying on data given to him by the COO without independent verification. However, ultimately, responsibility for compliance and its associated rules falls on the investment advisor, not on the outsourced CCO. So the CCO, if in an enforcement action, in an examination that results in deficiencies and disciplinary actions, if the CCO has exhibited good faith attempts to implement a culture of compliance, to assert authority in developing appropriate policies and procedures and has tried to compel others to adhere to them. And if the CCO has exhibited good faith efforts to do that, and there are compliance-related deficiencies, that's ultimately going to fall upon the firm and likely the CEO. We have seen enforcement actions, disciplinary actions taken against CEOs and against the firm where the CCO made good faith efforts, there were compliance issues, and the SEC did not hold them responsible. They held the firm and the CEO responsible for not helping the CCO meet his or her goals and putting in place a culture, which again I said, the culture is built from the inside, not the outside, not putting into place the compliance culture that would allow that CCO to flourish and do well. So, using an outsourced CCO, our firm is used as an outsourced CCO, and we've been successful with it with many firms. Again, it comes back down to qualifications, competence and knowledge, empowering with full responsibility, and then being in a position to have authority to compel others to adhere to the policies and procedures. That's where it's that important. You know, you can't just hire an outsourced CCO and think that the SEC is like, oh, you have an outsourced CCO, great. There actually has to be substantive action taking place. So a CCO that comes once a year or twice a year is not appropriate. You want someone who's coming often, establishing relationships with employees, and really having access to the firm's management team and documents to really ensure that the compliance program is functioning and being adhered to. Alrighty, well that's all for today's presentation. If you have any questions, please feel free to email us at compliance@myralawyer.com. You can also call us at 770-462-2118. Thank you so much, guys, and have a great day.